Welcome to the overview of civil rights and equal rights under the law. Chapter 15 in the online textbook, Chapter 16 in the hard copy, and I'm glad you're here. I'm Mr. Rodman here to take you through it. If you haven't checked these out, these videos are a great foundation for starting into this chapter on the civil rights movement. There are 3 of them. They're posted on my MCPS Classroom, and they will take you through the 1950s and 1960s. They're hosted by former ABC World News Tonight news anchor Peter Jennings, and they did a whole series on these. We use them in U.S. history class, but they're really phenomenal in terms of really giving you the context of what's going on in the country, not just in the civil rights movement, but also what's going on at the time. At this particular point in history, and at the same time as what's happening with civil rights. And it really gives you some good context as we move into this chapter in terms of the civil rights movement and its impact within government and governmental action. So hopefully by the end of the chapter you can come back to these questions and answer them with more knowledge and detail in terms of trying to be able to address them. So we'll definitely come back to those at the end. Let's start, though, by looking at the requirements for citizenship. Now, we talked in the last chapter in Civil Liberties about the idea of due process clause and equal protection, and we'll look more here at equal protection under the 14th Amendment. And the significance of the due process clause in particular, we talked in the last chapter about due process as it helped with selective incorporation. There would have been no selective incorporation were it not for the 14th Amendment. The primary author, John Bingham, to his credit, really trying to make sure that the South and the southern states were going to have to abide by the law, and they do this by crafting a due process clause within the 14th Amendment that really starts to apply, at least hopefully, hoping that the Bill of Rights will slow under the due process clause will be applied to states, so that it is a uniform process, a standardized process that is procedural in nature, but is applied by the national government. You can't interfere with these individual rights, and the state governments can't either. And so that's really what we talked about in the last chapter. In this chapter, we look at the idea of citizenship and equal protection, those clauses that are also in the 14th Amendment. And the first one we talk about here is this idea of birthright citizenship. Keep in mind there were a lot of former slaves, freed slaves that are now free, and they are concerned about, well, am I a citizen? Am I not? Do I have to, what do we have to do here? How can I get on a level playing field when the course is essentially stacked against me at this point? And so the citizenship clause is really designed to address the issue of naturalization, and that is that anyone who was born here is a citizen, and that includes literally all of the freed slaves at that point, making them citizens because they were born here, and then also describes the process of naturalization in terms of filing for that naturalization with the government, and that being granted through the national government, mind you, not through the states don't grant that naturalization. It is the federal government, and then within state localities that we have that, but it is the federal government that handles that naturalization process. And the 14th Amendment really outlines that process. And the reason it is there is really to, again, to make sure that the southern states that seceded and have joined into the Union, who have to accept the 14th Amendment in its entirety in order to get back into the Union, to make sure that they understand that this is the process we are going to use for making people citizens, and you can't do anything about it, essentially. You have to agree to it in order to get back into the Union. And so that includes all of the freed slaves that are in your state. They are now citizens. And if there are individuals who along the way want to become citizens, this is the process we have for making that happen. Okay, so the question is always, do legal resident aliens or undocumented aliens have rights? Now, the Constitution, and we see this this came up with the census, the 2020 census this past year, about the idea of counting all persons. The Trump administration wanted to only count citizens. That kind of withered on the vine in the courtroom and in the courtrooms, and because the Constitution really talks about persons having rights, not citizens. In terms of citizens, they look at that in terms of people running for office. They would have to be citizens, or to vote, you would need to be a citizen. But in terms of free speech, in terms of being counted, in terms of the due process, they're saying persons. They're using the term persons, all persons in these cases, and so that is a unique distinction in trying to broaden the scope and make this applicable to everyone in the United States, not just citizens in that respect. So some background. Obviously, we have the Civil War has ended. Reconstruction is taking shape, and with the election of Rutherford B. Hayes, he's made an agreement to win the Electoral College because, as you know, Samuel Tilden won the popular vote. Rutherford B. Hayes won the Electoral College and won it by essentially agreeing to end Reconstruction in the South. This is going to give Southerners a leg up in terms of reinstituting things like Jim Crow laws and black codes across the South, and is really going to be how they regain their power in the southern states. And so they're going to use everything at their fingertips to try and regain that power, or at least keep that power in their hands, and subjugate the power of blacks at the time in terms of trying to gain their freedoms and become citizens and try and start a whole new life. So you also saw that in the North, people really didn't do anything. There wasn't a whole lot of they didn't have a whole lot of power over what was going on in the South. The Southerners didn't really kind of step in. The Northerners didn't really step in to do anything there. And then you had the Supreme Court stepping in on the 14th and 15th Amendments, but they were very strict constructionist, and so they really didn't get involved. And we wouldn't see the 14th Amendment start to be incorporated until 1925. So, that's 50 years away. So this is 50 years at least, and we would see it go on, into the 1950s and 60s, even almost 100 years, in which white supremacy really goes unchallenged in the South. We would see a lot of things taking shape in terms of President Truman coming in to desegregate the military in 1948. And this is where we start to see things start to take shape. Brown versus Board of Education is the unanimous landmark decision in the Supreme Court. It was really where they're reversing themselves from the 1896 case of Plessy, which said segregation was the law and it was constitutional. Then a year later, we have the Montgomery bus boycott, which is again significant in showing that blacks in the South do have power, and they do need to raise their voices and make their voices heard, and they did that through the bus boycott. And this is really the foundation with the SCDC that leads Dr. Martin Luther King and other leaders of the SCDC into the civil rights movement that we would see in the 1960s. Now, let's talk about Brown for a second. This is significant because it is a significantly huge landmark case because up to this point, the court has said that segregation is constitutional, it is the law, and people have to abide by it. And then, and that was a ruling from Plessy v. Ferguson in 1896. So here we are, 58 years later, and Brown versus Board of Education, the Supreme Court says unanimously reverses itself in saying that segregation is unconstitutional, that we need to integrate schools and we need to do it. Brown versus Board of Ed 2 would say we need to do it with all deliberate speed, but this essentially bans the idea of de jure segregation, the idea of a court stepping in to ban segregation. Now, this leads to another term that we try and address here, the idea of de facto segregation, people separating by moving in different places or discouraging or encouraging people to move into certain communities. The de facto segregation is by what's actually happening in real life versus de jure segregation, which is a jury essentially or judicial system essentially desegregating or stepping in to rule those segregation laws unconstitutional. So we see quite different terms here, and we see de facto segregation. All the way up even into today, we see firms all the time that their lending practices are very de facto segregationist. In terms of redlining, if you want to apply for a loan and you're getting it in a lower income neighborhood that is predominantly of a particular race or ethnicity, you're going to pay a higher interest rate to do that. That's the idea of de facto segregation. They're discouraging people from investing there, and those things are illegal under the 14th Amendment and Equal Protection Clause. So, but again, how do you find those? How do you prosecute those? How do you weed those out? It's very hard to do, and even in today's society, we continue to see those kinds of things cropping up. The idea of separate but equal would end with the Brown Board of Education decision. But obviously, as I mentioned, de facto segregation still continues, even though de jure segregation, the process of de jure segregation began to end in 1954. I would say began to end because certainly it is an ongoing struggle, even in situations that we continue to see where there are problems. Not nearly as much in the de jure as the de facto, but we continue to see issues. This is an ongoing controversy. And then we saw affirmative action, the idea of trying to level the playing field. You see the Shirley Chisholm quote down there. The difference between de jure and de facto segregation is the difference between open, forthright bigotry and the shamefaced kind that works through unwritten agreements between real estate dealers, school officials, and local politicians. And that's what I meant by the de facto. A lot of them can discourage people from investing in particular communities just for the idea of redlining, the idea of drawing red lines around communities that are people of color or are of people of less socioeconomic status, less income, and just through those decisions and those processes, they're discouraging people from investing in those communities, which contributes to the degradation of those communities, and that's part of the problem of de facto segregation. Is again, it's really hard to try and address. So let's go back to this idea of the civil rights movement and look at Dr. Martin Luther King's letter from a Birmingham jail. Now, this is an important piece, and I'm not going to go into it here. There is a great explainer on the next slide that really addresses this. But this is kind of the call to a movement in terms of what would be the civil rights movement, and he really lays out the facts that the country is not equal, that equal protection is there and is important for us to look at in the 14th Amendment and to get government to enforce. But we've got to do more than we're doing. We need more help in terms of making this happen. And so this is an important piece because it really does address the idea of a nonviolent message. Taking that from Gandhi, the method of protesting via nonviolence in terms of addressing the needs and the actions that are needed from the people. So we saw in this movement, what is he addressing? What is he trying to make change about? In addition to segregation, in addition to the segregation that we see across society, because it wasn't just schools, it was also lunch counters, and it was hotels, and it was restaurants and all kinds of communities. But you also saw a lot of these black codes, and here's some examples of things that Southerners would use to keep blacks from voting. I mean, this is just the voting aspect. Then you think about hotels and restaurants and lunch counters and other things, and you can see the significant burden of blacks in the South at this time, and how really the law was working against them. So you had the grandfather clause. If you could vote or your ancestor could vote, then even if you can't pay the poll tax or pass a literacy test, that's okay. You can vote, okay? And that's designed to get the white people out to vote. The white primary, only white people could vote in the South, the one-party South, as it were. Both of these items were declared unconstitutional by the courts, but we would see them continue to play out even into the 1940s with the white primary. Poll taxes. It wasn't until 1964 that those were prohibited. People had to pay a tax in order to vote, and the people who couldn't pay the tax were usually poor and or they were black. And so this was, again, another way for Southern whites to keep blacks from voting. And the final piece was literacy tests. And again, the Voting Rights Act would eliminate this, as the 24th Amendment did with the poll taxes. But the literacy tests were, again, things you had to pass, things that even white voters couldn't pass, as you could see with the grandfather clause. But yet they were expecting black voters to be able to do it. And really they weren't. They knew they had designed these tests in order for black people to fail them, because they didn't want them to vote. So they weren't anticipating that they would be able to pass it. They assumed that they would fail it, and that would be the end of it. But even that was outlawed when the Voting Rights Act was passed after the Civil Rights Act of 1964. The Voting Rights Act was passed in 1965 to eliminate loopholes like this one, the literacy test that we see here. So this all gives rise to the 1960s, the 50s and 60s in terms of the civil rights movement. We see this social justice on the Edmund Pettus Bridge with Bloody Sunday. After this was when President Lyndon Johnson called for a Voting Rights Act to close the loopholes. There you see John Lewis, the infamous congressman from Georgia, John Lewis, being beaten and arrested by a police officer. And the idea here was the Civil Rights Act had just passed. The Civil Rights Act of 1964 was passed, and it wasn't monumental because it was the first Civil Rights Act to ever be passed. There were many Civil Rights Acts that were passed going back to the 1860s. So for 100 years, there were Civil Rights Acts that were passed all the time. The problem was they were so watered down that they didn't have any teeth. There was no enforcement to them. And really, it was after JFK, after President Kennedy was assassinated, that Lyndon Johnson, his vice president, who was a wheeler and dealer in the Senate, and we look at that in more detail in U.S. history class, but he was a wheeler and dealer in the Senate. He knew how to get things done. He was the majority leader when he was there. Then when he became vice president, he knew how to angle on bills, how to lean on people in order to get them to vote a certain way. And he said, let's do this. Let's pass this Civil Rights Act. Let's make sure it has some teeth to it. And let's do this in honor of our slain president, in honor of President Kennedy. And it was a genius idea. It worked. He got Dr. Martin Luther King's help, which you can see there. He's giving one of the pens that he's using to sign the bill into law. He's giving it to Dr. King first. And the reason for that is because they really worked together in order to pass this thing and to get senators to sign it. It overcame one of the longest filibusters that we had ever seen from Strom Thurmond of South Carolina and Robert Byrd from West Virginia, both tried and failed to use a filibuster to pass the bill. But they were going up against Lyndon Johnson. And if you know anything about Lyndon Johnson, you know you don't go up against Lyndon Johnson when you're trying to get legislation through. He is like a Mack truck rolling down a highway. You're not going to stop him. And they didn't in this case, and he was able to get it passed. And but he noticed there were loopholes. There were some things that they didn't get in there that they should have. And the Bloody Sunday events that he was watching in the White House on television, he was just awestruck by. And the idea here was he said, I want to speak to Congress. The next day, we went before a joint session of Congress and said we need to pass a Voting Rights Act to close the loopholes. What people like John Lewis were fighting for. This is the message. This is the act of our time. Now, this is a Southern Democrat who even voted against civil rights bills in his time in the Senate. Here he is, seeing that he wants to be on the right side of history here and really kind of changing his views for the purpose of where the country is going, seeing where history is going. And and significantly really came around to wanting to support it and supporting the civil rights movement in that regard. And so, and he even uses the line "We shall overcome" in his joint speech to Congress at that time, really sending a message to the civil rights movement that he's with them and he has their back, and in trying to get this passed. So that is significant because it is the biggest legislation up to this point that really argues and protects minorities, and particularly blacks in the South, to be free from a lot of the black codes and Jim Crow laws that were on the books at the time. That really made a lot of them unconstitutional at that point, and null and void, and that really changed the game. And like I said, with some of the the poll taxes being outlawed under the 24th Amendment, literacy tests being outlawed, all of these things start to chip away and break down the wall of segregation and the Jim Crow laws that we saw in the South. Now, some other cases, I mentioned Plessy versus Ferguson back in 1896. We talked about Brown. There's a couple of other cases here to mention that are also pretty significant in terms of civil rights cases. Loving v. Virginia was an interracial marriage case, again looking at equal protection under the 14th Amendment. The wife here being African American and the husband being white. They were violating the interracial marriage law in the state of Virginia, and they fought it and they won. The Supreme Court declaring that under equal protection clause of the 14th Amendment, that the law in Virginia banning interracial marriage was unconstitutional. We see again Virginia in U.S. v. Virginia in 1996, not that long ago, but the idea of the Virginia Military Institute only accepting men. And under the Equal Protection Clause, once again, of the 14th Amendment, we see U.S. v. Virginia admitting women as well as men to their academy, to that institute. It is a government-sponsored institution paid for with government dollars. Therefore, Equal Protection Clause, you got to bring in women, or you forfeit the money, which essentially it would crumble at that point. It would close up. Some other cases that we've seen along the way, we saw some gender discrimination cases that Ruth Bader Ginsburg argued before the courts. We saw the latest one with the sexual orientation based on the rights of the Civil Rights Act of 1964 last year. Sex discrimination included, according to the majority on the court, sex discrimination included sexual orientation discrimination under the Civil Rights Act. So that was significant. And again, using the idea of the Equal Protection Clause of the 14th Amendment to look at that gender discrimination and sex discrimination under the Civil Rights Act as well. So we've seen a lot of legislation passed since the Civil Rights Act of 1964, the Voting Rights Act of 1965. Another significant one is the Fair Housing Act of 1968. Up to that point, again, like I said, they could discriminate against blacks. Oh, you don't want to live in this neighborhood. Oh, sorry, that apartment's gone. There were lots of ways that people could get around having to rent apartments or sell houses to African Americans. And that was one way in which the Fair Housing Act stepped in to say, hey, under the 14th Amendment, Equal Protection Clause, this includes fair housing as well. We would see this expanded to education in 1972, looking at federal aid in 1988. I mentioned discrimination in terms of testing in job discrimination in 1991, and then the VMI cases I mentioned in 1996. So we see the Civil Rights Act really paved the way for a lot of legislation to come after it that really changed the game, really changed this. And it's because the Civil Rights Act looked at this and said it is illegal to discriminate in any public accommodation because of race, color, religion, or national origin. It also went on to say because of sex, looking at gender, and like I said, the Supreme Court ruled last year also that sexual orientation falls under that, under discriminate based on sex. This applied to inns and hotels, restaurants, gas stations. Again, there was a loophole here for housing. We would see that loophole closed with the Fair Housing Act of 1968. There was a loophole here with voting voting, and we would see that loophole being closed with the Voting Rights Act of 1965, closing those pre-clearance standards that were needed. And the idea there that a state that seceded from the Union had to get pre-clearance from the government in order to be able to hold their elections, and under the Voting Rights Act, and that was overturned in Shelby v. Holder in 2013. They took that portion of the Voting Rights Act away, but up to that point, the elections held in the South, the voting qualifications, and what was being done with elections in the South had to pass muster with the federal government, with the Justice Department in Washington. They would send people out to inspect and make sure that the law was being fairly applied, and that the elections were fair and were not discriminating against African Americans at that point. And with 2013, that went away. So we will see how that takes shape. Now, we also saw Shaw v. Reno come as a result of this Voting Rights Act. The idea of race being a factor, but not the predominant reason for redrawing a district line, what we talked about in Bakke versus Carr. So that's significant here in terms of the Voting Rights Act. But the Civil Rights Act and the Voting Rights Act, really the most significant legislation we've seen since the passage of the 14th Amendment in terms of trying to provide civil rights to African Americans and people of color. And we really see that as a game changer. That does extend to women. We see this, women get the right to vote in the 19th Amendment, 1919. Even though they're still not paid the same as men, we still don't have that. The Equal Rights Amendment was passed in 35 states, but you need 38. We'll see how that takes shape in this Congress. There is some rumor that the House may try and take that up in terms of trying to address that now that they have a Democratic Senate. We'll see, to be continued. But we still see women suffering in terms of different rights that men have that women do not. And pay equity is probably the most common in terms of what we see today. The right to vote was the beginning in terms of paving that way. Now, we talked equal protection. Let's talk about the Equal Protection Clause of the 14th Amendment a little here, because this really is the thrust behind the civil rights movement and behind a lot of the legislation we see today, not just in civil rights for people of color, but also in terms of gender, in terms of sexual orientation, a lot of them, and even disability, brought about because of the Equal Protection Clause. So notice here, no state shall deny to any person within its jurisdiction the equal protection of the laws. The little scroll over there says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So looking at that from due process, in terms of making sure that's followed. And again, we talked about that, the idea of procedural. Are you following the procedures? Are you following the processes of the Bill of Rights? But also the substantive due process. Is it fair? And that was an important piece when we look at some of the segregation that was going on. They looked at the 14th Amendment and said, this is a violation of equal protection, but this is also a violation of substantive due process. Is the law fair in terms of how it's being applied to people of color? And the answer that courts were saying was no, it wasn't. It wasn't at all. So this is government action, mind you, in terms of equal protection of the law. This isn't individual action. There are laws, and again, the Civil Rights Act of 1964 is really trying to address that, as well as Fair Housing, Voting Rights Act, that sort of thing in terms of private discrimination. But the idea here was it's providing the legal basis for civil rights and anti-discrimination laws. And the idea is it's not going to cover everything, but it really gives the court a framework to work from in terms of determining if the laws aren't being applied equally. That the protections aren't being applied fairly across the board, and that people of color or women or those being discriminated against based on gender or sexual orientation or disability aren't being equally protected under the law. And that really is significant, because it does lead to this idea of application. How do we apply equal protection? And it really is looking at three main areas of scrutiny. Okay, the first one is what we call the rational basis test. And this is if there is a rational basis for outside businesses or whatnot to discriminate, and what we call non-suspect classifications. This is the idea that a business can discriminate against you, and the one that usually comes up most often is either economic. You have we don't have equality of income. You really work really hard, you make lots of money, you keep it after you pay your taxes, right? But the other one is age. If I'm a construction foreman and I'm hiring workers to work on the job in this skyscraper that we're building 100 stories in the air, do I want to hire an 85-year-old man to go up 100 stories on steel beams, walking very finely in terms of helping us to build this structure? Well, probably not. They're not the most agile individuals, and the law says, under rational basis test, says I can discriminate in not hiring a person that's that old because that's probably not the best place for them. And the court agrees. They said this is a non-suspect classification. We can discriminate based on age. We can discriminate in that capacity, and the courts have upheld this. When states determine how old you have to be to get a driver's license or how old you have to be to drink, and that kind of thing, those survive the rational basis test because those are standards in which there is a logic to why those limits are there. Now, when we get to intermediate scrutiny, what we see here is there are some times in which there is a reason for why you would need to discriminate, but it's a much higher standard, and you're really going to have to convince us, you're really going to have to win us over here as to why that is. And so this is what we call quasi-suspect classification. This is usually used in either gender or alienage, essentially national origin, if you will. And so here we have, we're hiring someone to clean out. I own a health club, and it's busy all day long. 24 hours a day. We have people coming in and out, and I need someone to clean the women's locker room. And the people that keep coming for this job as a cleaner are men, and I don't need men. I need a woman. I need somebody who can go in there and women can feel comfortable with women cleaning and that not be a problem. So the Supreme Court says that's okay. You can discriminate based on that because there's obviously some type of a burden there that as to reasoning why you're doing so, and so they understand that. Now, another aspect, I mentioned national origin. Sometimes people need to hire an interpreter, and they need someone with a particular skill set that usually comes from a particular background in order to be able to do that. And if you're interpreting, you need to be able to speak the language. So I'm not going to hire someone that's coming from a different area that doesn't know the language. I don't need you. And the court says that's okay. That is a quasi-suspect classification. Yes, there's a higher standard here, but we can understand the intermediate scrutiny you're being put under, and that would qualify under that basis. Okay? But the last one is what we call strict scrutiny. And this says, you know what? There's really no reason why you would discriminate based on this individual in this particular circumstance. And so this is a really high bar. This is what we call a suspect classification, meaning that the burden of proof is really on you here, and there's really no logical reason for why you would be discriminating against this person. And this is where we see discrimination based on race, ethnicity, national origin in those other cases. Now, I mentioned intermediate scrutiny for national origin in terms of an interpreter, someone who speaks the language that wouldn't have the background or the acculturation in terms of being able to speak the particular dialects or tones or that sort of thing. And under intermediate scrutiny, they said that's okay. But strict scrutiny is the idea that, you know what, you really can't treat people differently here. And there's no real reason why we would allow you to do so. And that really is the strict scrutiny standard that is applied under the Equal Protection Clause. And so the court continues to look at these three areas of rational basis test: intermediate scrutiny and strict scrutiny, in terms of how they apply the law under equal protection. and where do they fall? So that is pretty significant in terms of trying to address how the equal protection of the law is applied. And the Supreme Court has established this standard that we see continue to be used today. Now, I mentioned the Fair Housing Act of 1948, significant in terms of closing a loophole in the Civil Rights Act of 1964 around housing, around mortgage lending, redlining, the idea of drawing red lines around communities of color that they want to charge higher interest rates if you're going to get a mortgage in that community, that kind of thing. So, or they're steering you away from that community. Oh, you don't want to invest in there. Your rates are going to be much higher. Why don't you go over here and invest in a house over in this community? That is the idea of steering. That is also illegal and very discriminatory in nature. But we continue to see people doing it. And Wells Fargo, the California-based financial services institution, Wells Fargo, just settled a multi-million-dollar lawsuit around fair housing and discrimination and community reinvestment because they did these exact things that I just talked about. And here we are in 2021, and we're still talking about this. And this law was passed in 1948. So there are lots of ways that businesses try and get around the law in terms of addressing this. And so time and time again, we see the law being applied, and again, going back to that idea of equal protection, there's no real strict scrutiny standard as to why you would discriminate against those groups of people in those communities, in those communities of color. And so that really is a violation of Equal Protection Clause, violation of the Fair Housing Act, and that's how the courts have come down time and again in terms of what we've seen there. Now, there was a concept that we haven't talked about much here called affirmative action, which really took effect in the late 50s, early 60s during the Civil Rights Movement, and into the 70s. This comes from the idea that President Johnson said, freedom is not enough. You don't take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say you're free to compete with all the others, right? And this is the little cartoon that we have down at the bottom there of equality versus equity. We've seen this time and again, right? The two on the left. But the reality is that the odds are stacked against people, and what we really see is many people are starting in a hole, while others are stacked on top of boxes, stacked to the ceiling, in terms of what the reality really is. But what we need to get to is this idea of liberation, the idea of tearing down the wall altogether. We don't need the boxes. We don't need the holes. We need to tear down the wall. We need to tear the fence down and put people in and help people get to a place where they can be free to compete, but helping them in that standard to level that playing field and give them a fair start. And what he's saying is, even that takes challenge and isn't always there. So affirmative action is this idea that we are going to hire quotas based on race, ethnicity, people of color, and different backgrounds, men and women as well, based on gender. And we're going to hire to fill those quotas to try and level the playing field. And so government steps in to do this. This isn't private industry. This is government that's doing this. And so they're doing this on government as well as applications for admission to colleges, government institutions. And so the Bakke case comes up. This is the idea of Bakke is applying for medical school. He has test scores that are higher than that many of the others, and has been rejected from medical school. In the California case, and he says, I was a victim of reverse discrimination because of affirmative action, because of quotas, I'm not getting in, and I haven't gotten in twice now because of that, and that's a violation of my equal protection. And so the Supreme Court actually agreed with him, and they said in this 8-1 decision here, they basically said that quotas are illegal. The idea of affirmative action and using quotas, you can try and level the playing field, and you can use race as a factor, but you can't use it as the factor. And they basically ruled quotas under affirmative action as unconstitutional. You can try and be supportive in terms of encouraging people to apply and encouraging people. That's why we have the equal opportunity employer, right? You can encourage people to apply for jobs. You can encourage people to apply for admission, but you can't do it. You can't do it solely based on, oh, you're a person of color, you get in, oh, you're white, you don't, because that is under the Bakke case is unconstitutional and a violation of the Equal Protection Clause. And so that's what we see today. Now, fast forward to a couple of cases we saw in Michigan. This is where the court is stepping in to refine their distinctions on Bakke even further. They said, yes, race can be a factor, but not the factor in undergraduate admissions. So in the Gratz v. Bollinger case, they said you can award, you can look at race as a factor, but not the factor, and you can't award points based on race. You can't do that here because the student body is so vast and so broad and so big that there's really no reason to do that. You need to do it based on their merits and their merits alone. But in the law school, in the graduate school at the University of Michigan, same school but graduate program, in the Grutter v. Bollinger case, they looked at this and said race could be a factor that is used to help diversify the law school because of the fact that people aren't starting from the same place. There's not a fair level playing field here. So using race to help diversify the student body is different here in the law school program, where in the undergrad program we can't see you using it as points being awarded or whatnot, but using it as a factor in a multitude of factors that are being considered, sure, because you've got such a large undergraduate school of students that that's going to kind of work itself out. But in law school, where it is predominantly white, it is predominantly male, how do we use race and gender to diversify? That's okay there. And so they said you can do that to diversify the law school. That makes more sense there. That's not a violation of equal protection in order to do so. So that's where we see two very different standards to the same school. Based on the type of program that it is. The undergraduate program, much larger, lots of students, versus the law school, a much smaller program. So where are we today with civil rights? Well, as you can imagine, we've come a long way. A lot of legal barriers have been removed, but there's still a lot remaining. And I think the Black Lives Matter movement that we saw over the summer really addressed that. And the protests taking place even at WJ, even within our communities, really showcases that. Socioeconomic disparities, the wealth gap, the achievement gap, a number of the wage disparities, and all of these continue to plague us in terms of fighting for those civil rights and trying to address that. There is more of a representation in Congress, but it is still and we've come a long way in terms of advancing those civil rights and civil rights protections, but it's still a long way to go, and there's still a lot that can be done there in terms of addressing those issues. Now let's look at this by gender for a second. Notice we have the Equal Pay Act based on gender. Again, great words, not necessarily a whole lot of enforcement based on that, because we can see that women are not paid the same as men in the private sector, notwithstanding. We see Title IX basically saying if you're going to offer a boys' sport that a woman can't play in, then you have to offer a female sport as well. And so otherwise you lose your Title IX funding under this Education Amendment of 1972. And that's significant because it says if you don't offer a girls' sport, then you can't offer the boys' sport without letting girls try out for it, because that would be, again, a violation of the Equal Protection Clause of the Constitution, of the 14th Amendment. And then the Civil Rights Act, as we mentioned, banning gender discrimination in public accommodations. There are some loopholes there in terms of fair housing, but the Fair Housing Act of 1968 really tried to address that too. We see this with disabilities and with the LGBTQ movement. So with the peoples with disabilities, we saw them start to take shape in terms of trying to address the needs of the disabled. And in the 1970s and 80s, they started to gain some lobbying momentum in Congress. It led to the ADA, which was passed in 1990. It's the Americans with Disabilities Act. This essentially required states and the national government to modify their buildings and to try and provide access for disabled people It banned employment discrimination, which again was covered under the 1964 Civil Rights Act, but it codified that in the Americans with Disabilities Act, or the ADA, of 1990. That was signed into law by President George Herbert Walker Bush, Bush 41. The LGBT movement we saw in U.S. v. Windsor, striking down the Defense of Marriage Act that just 20 years prior that had been signed into law by President Clinton. The Democrat from Arkansas, basically saying he was going to sign the Defense of Marriage Act. Republican Congress passed it. A Democratic president signed it. And in 2013, the Supreme Court ruled it unconstitutional. Said that it was a violation of the Equal Protection Clause under the 14th Amendment to ban marriage between opposite-sex couples, and the act itself. Now, it didn't legalize same-sex marriage until 2 years later in the Obergefell case, Obergefell v. Hodges, and this basically legalized same-sex marriage. States could legalize it, and I think Maryland did prior to that. I think it was in like 2013 that Maryland had a referendum on the ballot in 2012 to legalize it. So it took effect in early 2013. But as far as the nationwide same-sex marriage, that was the Obergefell case, Obergefell v. Hodges, in which it recognized licenses from other states in their states. I think they were married in Maryland on a tarmac, and then flew back to their state. It was either Indiana or Illinois, somewhere in the Midwest, and tried to get the state to recognize it, and they couldn't. And that's when they filed suit. So the Supreme Court said that, again, under the Equal Protection Clause of the 14th Amendment, that violated the 14th Amendment's Equal Protection Clause and was unconstitutional. Now, we have heard some controversy around this idea of a colorblind constitution. We heard this in the University of Michigan cases, especially the undergrad case. I think it was John Roberts that said something to the effect of, the best way to not judge cases based on race is to not judge cases based on race. But again, is that necessarily what we are aiming for? And I don't think Dr. Martin Luther King, looking at the civil rights movement, would necessarily subscribe to that. So, because the whole idea is looking at people where they are, and the experiences, the lived experiences, and the culture that they bring to the table from those aspects. So, and he talked about this in many speeches in terms of having people be judged by the content of their character and not by the color of their skin. And that really is the driver here. And the 14th Amendment really addresses this in terms of equal protection, but also in terms of that fairness, that substantive due process. Is the law fair in terms of how it's being applied? And that's an important aspect to keep in mind here as we look at the upcoming court and the decisions that they will be making. Is it being made from an equal protection clause? Is it being made from a colorblind constitution? Is it being made from a substantive due process aspect in terms of looking at this in terms of fairness and applying that to the law, and in either whether it's loose construction or strict construction, and applying that in terms of its merits? And that is where we will leave it. So there is a self-assessment section here, and you are welcome to pause the video and or look at the slides in terms of what you can answer along the way. But hopefully you found this helpful, and we will see you back with the top 12 highlights on this chapter on civil rights.